All rise. All persons having business before the Honorable Associate Judges now reside in the District of the Court of Appeal. Throw in there and give their attention. God save the United States and it's on the court. This on the court is now in session. Please be seated. It's on the way.
Good morning and welcome to the District of Columbia Court of Appeals. We have one case on the calendar today. It is in re Benjamin SOTO, 22 BG 601. We'll hear from respondent first. Mr. Kolker, when you're ready, please come to the podium, introduce yourself for the record, and let us know how much time you would like for rebuttal.
Good morning, Your Honors. I'm Peter Kolker. I'm representing the respondent. With me this morning is Casey Trombley Shapiro Jonas at counsel table. And Mr. Soto is in the courtroom on the first row. I'd like to reserve 3 minutes. And if I may it please the court. This is a case in which there are two intertwined issues. And we ask the court to consider both of them, and I'll explain the interrelationship. The first is our contention that there was not substantial evidence to support the finding of an 8.1A violation, that is to say, a knowingly false statement made by Mr. Soto in the course of the disciplinary proceedings before the ODC. The second issue relates to the sanctions, and we would ask the court to consider that the violation that is before you does not warrant the sanctions that are recommended by the board, and I'll explain why in a few moments. But briefly put, that recommended sanction of 6 months is an excess of what similar cases have resulted in by way of sanction, and I'll explain the similarity of the cases. This is at the heart of this case. This is an extraordinarily complicated real estate transaction. That
I'd like to comment on that. You make that point throughout your briefs.
yes,
And the essence of the problem here is that your client's response to disciplinary counsel's inquiry made it seem like a very simple and straightforward transaction. And that seems to me to be the essence of the problem here. They omitted a lot of details that obscured how complex this was.
well, first, let me bring you back to what we're speaking about here. This was a May 15th, 2015 letter. That's the claim that there was a knowingly made false representation.
I
The
understand.
letter was written by counsel. It was endorsed by Mr. Soto, and we agree that it's his statement by reason of that. But the focus of the letter was on the concern that disciplinary counsel had first articulated, which was this a forgery? For that,
But the auditor master's reference to disciplinary counsel was concerned about more than a forgery. It was concerned about whether this altered deed accurately represented the consideration for this transaction.
and well, that issue was addressed, but the simple issue that was before the disciplinary counsel that it articulated in that May 15th letter related to whether this was forgery. So in other words, even though the auditor master may have triggered the inquiry in the way that you just described, the disciplinary counsel's letter focused on something quite different.
But it
Namely, was
seems
this
that
a forgery?
the auditor master was concerned that there was close to $500,000 potentially missing from the Little John estate because it had been tendered in consideration. And I think if your client had accurately represented the sort of, very complicated network that led to this transaction, that could have let him off the hook for that issue, could have maybe gone some way to addressing the forgery, though perhaps not. But it seems like, he really tried to simplify this in a way that almost made him look more culpable rather than less.
Well, first, I'd like to point out Mr. SOTO was not even made aware of the fact that the auditor master was conducting an inquiry that he did. So he was not present at it. He was not knowledgeable about it. Had he been, he could have certainly explained the whole transaction, and there was no money missing. Nobody has ever alleged that. The transaction was one in which the consideration was restated as to what was really the proper value for
Right, and
taxation.
he could have said as much in the May 15th letter, right? Instead, he said that this Lengiswell, which didn't even exist until 2012, was somehow both the owner and the lender of the property that dates back to the 1990s.
Well, the letter, I acknowledge, was not an artfully crafted letter. But again, I want you to focus, if I may, on what the issue was that the letter was addressing, which was the forgery. I also would like to point out to you that in describing the relationship of Lengiswell to this property, the salient point is that it had the characteristics of the lender for purposes of being able to take a deed in lieu of foreclosure.
Would that entity have been the one that could have called in this loan if the deed in lieu of foreclosure hadn't been executed?
Eventually, yes, but not at the outset.
But at the time of the alteration of the document.
Yes, at that time, Lengiswell was in a position Lengiswell became the assignee of the notes that underlie this transaction. And those notes date back to 1996 and went through a series of holders of the notes. The ultimate holder of the note was Lengiswell, and that's why Lengiswell was able to get a deed in lieu of foreclosure. That assignment happened informally because the note holder was Mr. Duggan, the owner of this Adams Morgan bar known as Madam's Organ. And Mr. Duggan informally assigned the notes to Lengiswell, which was an entity he created, his wife being the actual only owner of it. And she stood in the position, or Lengiswell then stood in the position of lender with the capacity to foreclose if it had chosen to do so, or accept a deed in lieu of foreclosure, which is what happened. So what I want to focus on here, and I don't want to get too lost in the weeds because there are a lot of weeds to this transaction. But the essence of the May 15th letter was to show that there was not a forgery involved. And I want to stress to the court, if I may, that the hearing committee concluded there was no forgery. And the board accepted that, and nobody has challenged that. There's no exception.
I don't know how that response really goes to whether there was a forgery or not. I mean, it seems like there was a forgery, and the lack of a claim of a challenge to the 8.4 violations, I think demonstrates that. So it seems more like the explanation was not whether there was a forgery, but why your client thought that there was consideration. And so I don't understand how I'm missing something.
I'd like to address both of those elements of your question, if I may. In the first place, forgery would have required a finding of intent to defraud. There was none. Mr. SOTO never benefited anything from this change in the consideration, and nobody has alleged that.
Well, I mean, fraud, I don't think requires that your client benefit from it, right? It just has to be a misrepresentation that.
Well, it takes more than that. I think it takes intent, and there was no intent in the change of consideration. To the contrary, the intent was to correctly describe what the transaction was. And if I can briefly explain what I mean by that, initially and you have to understand, normally a transaction like this, which would have involved both a transfer of title and a loan, those would have normally coincided, taken place simultaneously. In this case, because of the unusual characteristics of it, the deed was executed first in December of 2012, but could not have been recorded until February 2013 when the loan was made available. And it's because of that separation that the realization came that the deed had been incorrectly prepared, because it reflected a consideration of zero, which would have resulted in taxation being imposed on the whole fair market value of the property, about $850,000. This was not a zero transaction. And it was not an $850,000 transaction either. So Mr. SOTO determined the way to properly calculate this and verified that in a conversation with the recorder of deeds as to methodology. And that's a verification that was accepted also by Mr. McKeon, who was in the Office of Tax and Revenue, and recognized that the way Mr. SOTO conceived the calculation of consideration was correct.
So his
Mr.
calculation.
Cooper, go ahead.
Oh, no, go ahead.
If you'll forgive me, I think you're getting too much into the weeds here. The hearing committee found that Mr. SOTO made statements and omissions which were knowingly false and deliberately misleading. The board also concluded that the statements and omissions were deliberately misleading. Given our standard of review, how can we disagree with those conclusions?
Because I think there was not substantial evidence to support them.
It doesn't take much under our case law to constitute substantial evidence.
Well, I think the crux of this is knowingly, whether there was a knowingly false statement made. That's different from a statement that might have been in error or imprecise. And to find that there was knowingly falseness made in the statement would imply some reason that Mr. SOTO would have had to obscure this. There was none.
He was taking shortcuts.
Well,
And this helped present this situation as just ho-hum, standard buyer-lender transaction, nothing to see here, folks.
well,
And that's the nub of the problem.
well, I don't really think so, if I may say, because if Mr. SOTO had provided a 15-page letter, and it would have taken that to explain the transfer of the notes from 1996 to Perpetual Bank, which went out of business, to the Levin estate, which bought them, to Cole's Farm, which bought them afterwards, to Mr. Duggan and his corporation, and to Lengiswell. That's a pretty long chain of events and has no bearing on the issue that was raised by disciplinary counsel, which was whether there was a forgery. So there was
You seem to have tunnel vision, and I don't say that to be hostile, but I at least view this as involving more than a potential forgery. It's a misrepresentation of a transaction that caused havoc in probate court and might have had an impact upon the taxes due to the District of Columbia. So to say that it is only a concern about forgery seems to be missing the larger picture.
Well, I don't agree with your honor that this was a misrepresentation that caused the auditor master to do something. The representation you're referring to here that occurred in May of 2015 post-dated the auditor master's inquiry by 2 years, so it couldn't have affected it. So, and again, I want to stress, and I do understand your point that maybe I have tunnel vision because this is a complicated transaction. But I think the focus of this has to be whether there would have been a reason or was a reason for Mr. SOTO when he endorsed the letter that his counsel wrote at the very beginning of an inquiry, which began in March of 2015.
But whether there was a reason, that to me seems to go to materiality, which isn't required, not did he knowingly make a misrepresentation.
Well, I think in order for there to be an 8.1A violation, it has to be knowingly false.
So are you saying that he did not know that Lengiswell was not on both sides of this transaction at the time this letter was written?
No, I'm not suggesting that. I'm saying
Okay,
that
so he knew that that was false, and yet he signed off on its representation in the letter.
Well, knowing falseness implies that there is a reason to do something as contrasted to a mistake.
Well, no, I think you're challenging an intentionality element.
Yes.
But that's not the mens rea that's in the rule. It's knowing, not intentional.
Well, I understand that, but a knowingly false statement is one that is made for a purpose.
Well,
If you make a an error, that is not necessary, even if you know that the error, that on retrospect that you've made the error, that doesn't make it knowingly false. I would like to, in the few minutes that I have here, I also want to turn to the issue of what is the appropriate level of sanction in this case. And we have shown in our brief that in comparable cases in which an error was made in a document and then it was changed and then submitted and relied upon by somebody, by some authority, that the appropriate sanction is in the 60-day to 90-day range, not in the 6 months, and certainly not in the 1 year that that disciplinary counsel has sought in its brief. If you look at the Schneider case as an example, it's one in which the respondent in that case submitted, I think it was 8 different receipts that he changed in order to get reimbursed of his expenses. And the court recognized that although he did that, it wasn't with any improper intent, because the total amount that he was seeking by that alteration coincided with what he'd actually spent but didn't have receipts for.
Counsel, are you sticking to cases where the individuals at issue had prior violations, a record of prior violations?
Well, in that case, we don't have, Schneider did not have a prior violation, but there is a case, Saul Rosen is the case in which the respondent did have prior violations. And in fact, in the Rosen case, he made 3 separate misrepresentations to the court. And he had a prior history. And indeed, he even had a concurrently pending case on another matter.
But he was only charged and found that he violated a single rule. And here there were several rule violations found.
Well, the rule violations are maybe enumerated, but they all relate to the same conduct.
But they relate to different conduct around the same transaction, right? One is switching the notarized forms without consent. And then the other 8.1A that we're discussing today is representations to ODC when they were trying to figure it out.
Well, in the first place, I want to turn the clock back here a little bit. The letter, the May 15th letter that we're speaking about here, was the very first document that was submitted to ODC. But the process lasted for 5 years, and there were thousands of pages of documents. Everything was disclosed to ODC. If the letter initially submitted by the initial counsel was not as precise as it should have been, that was remedied by a fulsome disclosure of all of the elements in this case. The hearing and
perhaps that 5-year inquiry would not have been necessary if you had added a couple of sentences to your letter of May 15th.
In retrospect, it would have been better. I can see that, but I don't see that that makes it a knowingly false statement. Now, again, if you look at the sanctions, if I look at the Rosen case as an example, and I want to refer to the Powell case also, which disciplinary counsel relies on. In Powell, the sanction was for a year, but there was a situation in which the respondent had lied to the court before whom he was seeking admission. That was the Colorado court, federal court, about pending matters in this court. That's a very different kind of situation.
What about the Reback case? I'm probably mispronouncing it, but the Reback case, which both the committee and the board relied on, was a 6-month suspension, and it seems quite analogous on the facts.
Reback involved a situation in which he was seeking to cover up his own negligence and trying to conceal from his client that he had failed to attend to the case. And he did it with documents that were submitted to the court under oath, as though they were hers, he knew perfectly well that he had no authority to do that. In contrast, Mr. SOTO believed that he had the authority by Mr. Littlejohn, the personal representative of the state, to make the change. That's something that he learned from Mr. Duggan, who was the purchaser or ultimately the owner of the property. Legiswell was the actual owner. And by the way, Mr. Littlejohn went back in and signed documents in February of 2013, when the seller was signing documents, and the documents that he signed were done when there was a correct statement of what the value of the property was. So it's quite a different situation in Reback, where Reback had no pretense of authority to make the changes that he did, whereas Mr. Soto thought that he did, and that turns out to have been corroborated by subsequent actions of Mr. Littlejohn.
Why does it help Mr. Soto's position that he learned through his client that Littlejohn might have been okay with this instead of going through Littlejohn's lawyer?
Well,
I spent a lot of years thinking about Rule 4.2 violations and going behind a lawyer's back. And so I just wondered, in approaching this case, why is that a mitigating factor for your client?
well, first of all, you need to, if I may, you need to understand that Mr. Soto is not representing a party in this transaction. He's running a title company. It's a little different from if he were an adverse lawyer. But I acknowledge that it certainly would have been better for him to have gone to Ara Parker, the attorney for Mr. Littlejohn, and he thought that was going to be attended to by his office. It fell between the cracks. It was the mistake. He has been apologetic to it and acknowledged it for years. So it was the point I'm making here is not that going to or learning about this from Littlejohn indirectly through Duggan, because he didn't speak to Littlejohn directly. Mr. Soto did not, that is, was not the preferred way, but it still provided him a basis for thinking that he had the authority to do what he did. And that contrasts with the case in which there's a 6-month sanction, and certainly the cases where the sanction's a year.
So why would anyone think they had the authority to do what he did? What he did was to alter a legal document after it had been notarized. I don't see where anyone gets the authority to do that.
Well, again, this goes to the issue of what the sanction is. I'm not contending that that alteration is a proper activity. But in doing it, if Mr. Soto thought that he had the authority to do it, it's a mitigating circumstance as contrasted to those cases in which the respondent, like Reback and Parsons, knew full well that they didn't have the authority to do what they were doing. Surely he should have gone to Ms. Washington. He says that. He said, I don't know how we missed that, but it happened. This is one transaction, and I would like to, I don't want to belabor this point, but it is worth making. The transaction was involving a 12-year series of events and mishaps along the way. That included foreclosure efforts which had failed. It included changes in the deed that eliminated reference to the failed foreclosure when the title insurers said it wasn't necessary to have them in there. It involved 15 witnesses before the hearing committee to explain this transaction. Over 7 days of testimony with 200 exhibits. That's a measure of the complexity of the case.
But that's the reason why Mr. Soto was brought in to execute this transaction correctly. And it seems like switching the paperwork when it's already been signed and notarized is certainly not doing what he's supposed to be doing by the book.
Well, I agree that change, and we've acknowledged that, and that is the 8.4C violation. We recognize that. My discussion of this issue is related to the subject of sanctions and what is appropriate under the circumstances.
Right. And it just seems to me when someone, their entire sort of job or role here, right, is to make accurate representations to the recorder of deeds, here also to the auditor master, that it seems like this isn't a sort of one-off, someone accidentally staples the wrong notarized thing and submits it, right? I mean, this was sort of a very intentional decision on his part in connection with the sort of core of his job.
Well, again, there was no misrepresentation by Mr. Soto to the auditor master. He didn't even know what was happening. And there was no misrepresentation to the recorder of deeds. I just point out to the court, if I may, that there's never been a question about from the recorder of deeds as to the propriety of the tax that was collected by the district. So the error is not a misrepresentation. I acknowledge.
I mean, the
Judge Fisher,
board found otherwise. The board says that he acted intentionally in altering the previously signed documents and intended for the altered notarized documents to be passed off as originals to the recorder of deeds.
Well, as I said, we acknowledge that happened. And, you know, as I said, it's an issue of what is the level of sanction for the error that took place in doing that when he thought he had authority to do it. Not correctly obtained. I acknowledge that. And I acknowledge that it would have been better if instead of submitting a 5-page letter, counsel had submitted a 25-page letter, which would have tracked the entire history of this transaction. But being practical, focusing on what was of key concern, which was the allegation of forgery, never sustained, I might say, I think one can understand why the counsel at that time focused on what she knew from what limited information was available to her in a response that was due to the bar.
It seems like you're trying to say that the sanction of 6 months wouldn't be warranted on just an 8.1A violation, but here we do have several other violations. So why isn't the entire mosaic enough to support a 6-month suspension? Because
I think that when you look to comparable cases, if you look to Schneider, if you look to Saul Rosen, if you look to the Austern case, which are different. Austern is quite an extraordinary case in my view, but it sets the measure of what is the appropriate discipline level. Austern was a case in which the respondent assisted his client in perpetrating a fraud. And Mr. Austern was a well-known figure in the disciplinary bar, so to speak.
Well, so counsel, on that note, I mean, I understand that your client spoke to the recorder of deeds and sort of got the okay on this, but isn't it notable that this was a departure from his usual course in these types of transactions and was only done in response to, I would characterize it maybe unfairly, but pressure from a party to this transaction who clearly wanted to pay lower transaction costs. This was a finagling of the amount in order to appease a party who was clearly pressuring your client, perhaps unfairly, but.
Well, I think that what Mr. Duggan did was to question the amount of recordation tax, and I think you can understand why. In a transaction in which recordation tax might have been imposed at the level of an $850,000 tax assessment, because the deed was shown as a zero consideration deed, and the district has a rule when a transaction is below 30% of assessed value, you apply the entire assessed value. And Mr. Duggan could and did rightfully say, well, just a minute, imposing a recordation tax based on $850,000 when I've never paid $850,000, that's wrong. And it's because of the unique characteristic of this transaction in which the title document, that is the deed, was executed 3 months before the recordation tax form was prepared and filled out, or reviewed, I should say, not prepared, but reviewed, and the discrepancy between actual amount and stated amount was became more evident. So I think that you can think of it as finagling, but in reality, if Mr. SOTO had wanted to ensure that only the minimum tax had been paid to the district, he would have said, well, 30% of $850,000 will get you to the minimum level. So that would be, say, about $250,000. But that's not what Mr. SOTO did. He said, let's take the deed, the value of the promissory note that you paid to buy these 3 notes, $350,000, add the taxes that you paid during the years or that you thought you owned the property when you really didn't, put them together. We can't do it with precision because nobody has the records going back that far. The best estimate is $450,000. And that's the number that was put in, not the lowest number that could have been put in.
Counsel, I think we have your argument, unless my colleagues have anything else.
Thank you, judges. I did reserve 3 minutes, so
We'll give you your 3 minutes. I know we have held you well over time, so we'll give that back to you on rebuttal.
Thank you.
And we'll hear now from disciplinary counsel.
May it please the court, Jack Metzler for the Office of Disciplinary Counsel. There's been a lot of discussion so far about the two issues that are briefed that are in the briefs and before the court. But I think it's important to keep in mind the issues that are not in dispute. And those are Mr. SOTO took the signature page from an executed document that was notarized off of that document and attached it to a different page, a deed, a first page of a deed that described a very different transaction from the original. The parties were different and the consideration went from $0 to $450,000. The hearing committee, you heard a lot that there was no forgery. Well, the hearing committee found that was a forged written instrument. That's page 82 of the hearing committee's findings. That's not challenged. It was a forged document. He then uttered that document by submitting it to the recorder of deeds, presenting it as a genuine document, which it wasn't. He did the same thing with the tax form. Well, not the same thing. With the tax form, he took the signature page and directed his staff to white out the tax amounts and write in different tax amounts, saving his client about $12,000. And he recorded that with the recorder of deeds, representing it as a genuine document, which it wasn't. And if you go and look at the property records in the District of Columbia for that property, what you're going to find is that forged document is the document that purports to transfer title from Mr. Littlejohn's estate to Len Jeswell, the new entity. So and that's the basis for the 8.4C violation, which Mr. SOTO does not challenge. And if you go read the deed, the forged deed that's in the property records, you'll see that it looks very much like what is happening is the entity Len Jeswell is paying the Littlejohn estate $450,000. When the auditor master read the document, that's what he thought. And he wondered, where did this $450,000 go? What did the Littlejohn estate distribute that to the heirs of Mr. Littlejohn, or didn't it? That was a very reasonable thing to think. And so Mr. Littlejohn and his counsel then had to navigate a probate court proceeding. Mr. Littlejohn had to go in and testify, just explain the document that is in the property records is not the document I signed, and it does not represent what happened. I did not receive $450,000. So that's the basis for the rule 8.4C violation, and Mr. SOTO doesn't dispute that. But those facts are very pertinent to the issues that are in dispute. And I'll start with the 8.1 violation. In his letter, in his letter to disciplinary counsel, Mr. SOTO describes one entity that is the buyer of this property, that is also the lender of this property. And he says several things about that entity. He says it provided a loan to Mr. Littlejohn. Len Jeswell did not do that, couldn't have done that. It did not even exist.
So, counsel, I hate to cut you off, but so I think we all agree that the Littlejohn estate did not receive $450,000, and that caused a lot of problems in the probate proceedings. Understood. And I understood that Len Jeswell did not exist at the time and could not have been the lender in the strict sense of that term. Do you agree that in some theoretical manner, $450,000 could be considered consideration in this case, in the sense that it was a foregone amount that could have come back to whoever was holding the right to call in that loan, which your colleague on the other side said was Len Jeswell?
Okay, so two answers. The short answer is no, I don't agree. And the reason for that is in the DC code section 42-1101-5, maybe that's plausible. That says in sort of passive language that consideration is the amount that, is paid, without talking about who paid it and to whom. But there's an exception. That definition does not apply under the circumstances described in section 42-1104. And what that section says is if the document at issue is a deed transferring the title to real property, which this was, then the consideration is the amount paid in exchange for executing the deed. Now, Len Jeswell paid, there's no dispute about this, Len Jeswell paid the Little John estate $0. So the correct consideration is $0. And I apologize, I don't think this argument is in our briefs. We discovered it in preparing for the argument, but I mean, I in candor have to tell you that is my interpretation. And then the second part, you say that you mentioned in your question that Len Jeswell and my friend says had the right to call in the loan. I don't think that is clear at all. What you heard in the explanation of that is that Mr. Duggan informally assigned it from his entity 2461 LLC. But if you go and look at the property records, you will not find any record of 2461 or Len Jeswell ever having the right to call in this loan. What you'll find is documents from Cole's Farm, which was I can't remember his name now, but which is not Mr. Duggan's entity, saying that these loans were satisfied. You'll not find any reference to any Duggan entity ever holding those loans. So could Len Jeswell have called in these loans? You know, maybe theoretically it could have if they'd gone through a whole bunch of extra steps. But keep in mind, you would have had to transfer the title to Cole's Farm and then transfer the title to a Duggan entity, and each of those are taxable transactions.
Wait, why would you have had to transfer? Because I thought they didn't have the deed at that point. They just held the notes.
Well, they held the notes. They had actually foreclosed at one point, but failed to record the deed. And the evidence was that they should have recorded the deed. That was a taxable transaction. So if they had gone through all the steps, and you can disagree with me on this, but I believe there would have been other taxable transactions. So omitting that middleman, and I'm just going to go back to what's not in dispute. One of the changes that Mr. SOTO made when he created the forged deed was to remove the reference to the foreclosure, remove the extra signatory, which was the Cole's Farm representative. He changed the parties on the deed. And so that is very relevant to the 8.1 violation because it's the same thing, right? He says, oh, I was just describing what really happened. What really happened was Len Jeswell was essentially the lender, and the Little John estate was essentially, the one that held it. And so I was, just sort of smoothing it over. But that's exactly what he did when he created the forged deed. He smoothed over the existence of Cole's Farm, the fact that Cole's Farm owned the notes, and he acted as if Len Jeswell was Cole's Farm, which it wasn't.
And Cole's Farm was on the original document, correct? That
yes.
Had been signed and notarized?
Yes, I can't remember whether Cole's Farm's name, but certainly I think it's Mr. Basil, was essentially the representative holding the trust for Cole's Farm.
Mr. Metzler, what would disciplinary counsel have done with all this information about the complicated chain of events had it been laid out for you? We are led to believe that the taxing authorities of DC are not complaining. We have led to believe that nobody in the government is fussing about this. What would you have done with this, I'll call it extra information?
Well, I think we would have investigated it. And
toward what end? You're not a tax collector.
That's true. But toward the end of determining whether Mr. SOTO had engaged in helping his client perpetrate a fraud on the government by withholding taxes, not withholding, but by changing the amount of taxes that were due on this transfer and perhaps covering up other transfers that now I'm not saying it would have come to any different result. I think ultimately the evidence that we had was the evidence we had, and we were able to present it to the hearing committee. But what's important about the 8.1A violation is that Mr. SOTO doesn't get to decide, what facts he can put forth for disciplinary counsel to investigate. And what he definitely can't do is make false statements of fact.
Well, what do you make of your friend on the other side's contention that it wasn't knowing and that also you sort of got the full package of the transaction over the course of the investigation?
I think the suggestion that this wasn't knowing is hard to take seriously. The letter goes out of its way to say, no, the buyer is the lender. And then it says the lender provided a loan. The lender foreclosed on the loan. The lender didn't record a deed. Well, you've already told us who the lender is, and it didn't do any of those things. Those are false statements of fact. That is the language of Rule 8.1.
Let me invite your attention to the very last sentence of the letter, which says, please let me know if you would like further documentation or explanation as to the events that occurred. Isn't that some important indication that he was not knowingly trying to mislead you?
I don't think so. I think someone who is trying to mislead you would certainly say something like that, certainly could, insofar as if you describe a situation intending for the recipient of your description to miss something, then you would be happy, because if you succeed, you'll be happy to offer more information because you hope that they didn't actually catch the part. And let me just go. I would like to address the argument my friend made about why this isn't knowing. And he said it wasn't a knowing, these statements, which clearly were false statements of fact. He says that they weren't knowing because he was really concerned with whether this was a forgery. Well, the hearing committee held against him on that. The reason he says it's not a forgery is because this accurately describes what happened in the transaction. He lost on that. So if he's saying this shows why it's not a forgery and that was his intent, well, he was intending for us to conclude something that ultimately was not true, that the hearing committee found substantial, clear and convincing evidence, and the board agreed, and he doesn't even challenge that.
But isn't it possible he could be saying, okay, perhaps it was a forgery, and he seems to be acknowledging, I don't know if he was doing it at that time, but now that everything he did with the documents was improper, but couldn't he have been trying inartfully to explain why he thought that it was consideration in some respect?
So on the consideration issue,
and I know you disagree that it's consideration.
Right, I
but
do.
That was at least his explanation as to why he thought it was consideration, right?
Right. So the hearing committee and the board found that he thought this was okay, or at least it was within the law. And I say I disagree, but we didn't challenge. We didn't take exception to that. So I think this court can take that for as well, not conceded, but you can certainly take it as something the board held that we're not challenging. But even regardless of his intent with regard to the consideration, there's also the very important fact that he changed the parties, and the false statements are exactly about this. They're exactly about papering over, smoothing over, omitting the existence of these intermediary parties. And as Judge Alican said earlier, this isn't the sort of thing where you couldn't actually say, well, there were a series of intermediaries. Ultimately, Lenjeswell owned it, and we believe that the appropriate way to do this would be through this kind of transaction. You wouldn't have had to write 50 pages in order to not make false statements of fact. Certainly, it was not necessary to attribute specific actions to a party that did not and couldn't have done those things.
Let's talk about standard of review for a while. As you know, there's a lot of debate about what Mr. SOTO's mental state was at the time he endorsed this letter. And there are findings by the hearing committee and the board that say he knowingly made false statements and deliberately made misleading omissions. Are those findings of fact? Or are those findings of ultimate fact as to which we can make our own judgment and don't need to defer to the board or the committee?
So I think under the Crane case, those are findings of ultimate fact. And so they are reviewed de novo, except to the extent that they are based on findings of credibility, to which the hearing committee is entitled deference. And those can be overturned if they are not supported by the record. So if the hearing committee decides that a particular person is credible, but that finding is not based on observing the person's demeanor and so forth, then the board and this court are not necessarily required.
So is it enough for us to defer to the board and the committee that we think its findings are supported by substantial evidence in the record? Or do we have to be convinced, persuaded by the record that his statements were knowingly false and deliberately misleading?
I think it's enough to rely on the findings, it's so long as you believe that they are supported by evidence in the record.
Do you
But I
wanna
guess in the other direction, if there were findings that he did not deliberately mislead, and those were based on demeanor and so on and so forth, we'd be pretty much stuck with that.
Well, to the extent that they're supported by evidence and based on the observation of based on the hearing committee's evaluation of the witness, then yes, unless, for some reason it was clear from the record, from the cold record that, those were not supported. And I think you were inviting me to talk about the sanction.
Yes, thank you.
So with regard to the sanction, Mr. SOTO cites a whole string of cases toward the end of his opening brief, and those are 2 to 1. Not one of them involves a situation like this one, like a forged document presented to the government in order to change, in order to affect the transfer of title to real property. Just in the seriousness, none of those is even remotely close. The closest factual situation we think is the Reback case, in which there was essentially a forged.
Can I stop you before you go into Reback? If you think that the Reback case is the one that's most analogous, why are you asking for a penalty that was more than Reback, double what Reback was?
So if you read Reback, what you'll find is the court said 6 months is the lightest possible sanction that we can stomach for this conduct based on its seriousness. And it did that because of several mitigating factors, none of which are here. In fact, all of the mitigating factors in Reback are aggravating factors here. In Reback, there was a 15-year unblemished record of no discipline. Here we have a prior discipline, which relates to the very same thing. Mr. SOTO was disciplined for lying in a document that was filed with the Recorder of Deeds in Maryland. And apparently the informal admonition there was not enough to convince him that that's not an okay thing to do. There in Reback, there was complete cooperation with disciplinary counsel. Here, he has lied to disciplinary counsel at the very outset, trying to cover up his misconduct. In Reback, there was no harm. Basically, they were trying to cover up the lawyers in that case were trying to cover up the fact that they had allowed this complaint to become dismissed. So they put in a new one. It was the exact same complaint. Yeah, it was to their benefit, but the client wasn't harmed. No one in particular was harmed. Here, the change was very different, created a whole new transaction that never existed. It was presented to affect the transfer of property, and it caused substantial harm. Like there was a whole proceeding, and Mr. Littlejohn had to pay attorney's fees, which were not reimbursed by DOCKET or anyone else.
Does it matter that in Reback, there was a client And here, Mr. SOTO was not representing a client.
Well, Mr. Soto had a customer, so and so no, I mean, I don't think the short answer is no, I don't think it matters. As far as his sort of motivation for doing it, well, this is a customer who does a lot of real estate transactions. And so, you know, getting a favorable outcome for the customer is good for him, but it doesn't change his responsibilities as an attorney. And
To what extent do we consider that, I know you say this was still a tax problem, but that the district is not going after anyone for other taxes?
well, I think the testimony was that there really isn't a mechanism for going behind these recorded documents to make sure that they're accurate. And that's actually an aggravating factor here. In Reback, just like this case, the court said that when an attorney submits a document, you know, and presents it as genuine, it's his license that is sort of providing the stamp of approval that makes, this is why, I mean, this court, I don't know if this is still true, but the Superior Court used to let lawyers write checks, personal checks, but nobody else could, because they trusted that a lawyer is not going to write and balance a check to the Superior Court. And that's what's going on here. When the lawyer submits a deed and says this is genuine, probate has no reason to question it. And in fact, when Mr. Littlejohn's counsel tried to get this corrected, when she learned about it, she's, you know, emailing Mr. Soto saying, "Where's this $450,000? And you know, let's correct this to make it the transaction that it really was." He did not respond to her, but what she learned from the recorder of deeds is really there was nothing she could do. There's nothing they could do. There was no mechanism to go fix. But again, this forged document, which has transferred the property. And there's one more thing I'd like to mention about the Reback case. In Reback, the attorneys acknowledged their misconduct. And here, Mr. Soto says he's acknowledged it, but he hasn't really. What he says is, "I'm sorry I didn't tell the lawyer." But as Judge Fisher points out, there is no, to the extent he believed he had the authority to change a notarized document, that is not a reasonable interpretation. Everybody knows, the notary knows, you cannot do that. And in fact, he says it's a mitigating factor that Mr. Littlejohn came in and signed, you know, another signature page for the tax document. And I invite you to go look at that. It's at Exhibit 146, I believe. Disciplinary Counsel, it's Exhibit 146, and it's page 4. And what you'll see there is Mr. Littlejohn's signature, yes, on that page. It shows 0 taxes, and for some reason his signature is X'd out. So I don't know what to make of that. But if Mr. Littlejohn was available to come in and sign a new notarized document, why didn't they just have him sign a new deed, the one that he says was correct? I don't see how it's mitigating that he brought him in to sign this other sort of ambiguous tax document, but not the forged deed. Which anyway, so as far as his intent or his remorse, I don't think he gets any credit for that. What he says is, "Oh, this was unintentional. I didn't mean to harm anyone. I didn't mean to fool anyone or defraud anyone." Well, you don't take a document and present it as a notarized true document when it's not, without an intent to do that.
Let me ask you, I know I've asked this and I know you've answered it, but let me ask it again. I understand that Mr. Soto got into a lot of trouble because he was trying to keep Mr. Duggan happy. But that's not really the issue here. What was his motivation for lying to disciplinary counsel? I'm having a hard time understanding what his motivation or purpose was in making a knowingly false, as you say, statement to disciplinary counsel.
So I think Judge Alican mentioned that earlier. And the idea is he was, or maybe it was Judge Schenker, nothing to see here is essentially what he was trying to say. And if we had looked at that, you know, if we had an inattentive person reading that letter and said, well, this sounds kind of reasonable. They wanted to do this transaction and sort of it was initially the initial documents were not right, but they got fixed and everyone seems to agree that it was okay. We'll just close the case. So yeah, that was the motivation for concatenating these, for simplifying, for omitting relevant information. And in particular, when he says that Lynn Jeswell did all these things, that is the same as the misconduct. That omission is the same as his misconduct in taking the intermediary entity off the deed without telling anybody. And so I think part of the motivation is also that don't look at the parties to the transaction, because there were no other parties. When in fact there were, and those parties were important to the transaction and could well have been important to whether he had assisted Mr. Duggan in avoiding transfer taxes for the intermediary purchaser.
Counsel, we've also taken you well over time. Unless my colleagues have anything else, we'll hear on rebuttal.
Thank you, Your Honor.
Thank you.
Thank you. I'd like to address some of the points that were made by my opposing counsel and also some of the questions that were put by the court. And I want to start with a question from Judge Fisher. What motivation would Mr. SOTO have had to make the misrepresentations that are alleged to have been knowingly and falsely made in the May 15th letter? And the answer is none. And that is best demonstrated by the fact that he made 100% disclosure of all of these facts along the way. Yes, they were not all contained in the first document, but had he written, or his counsel written, an extensive letter that described every step, it would not have changed the way this matter would have been viewed, because the focus of the matter was about whether there was a forgery with an intent to benefit somebody at the expense of somebody else. And that's never been claimed. Secondly, I know this is in the weeds and the small weeds at that. The issue of removing the substitute trustee as a party on the deed is really an esoteric question. And you'll excuse me if I can explain this. In a foreclosure action, a trustee initially appointed as the trustee under a deed of trust is often replaced by a substitute trustee, somebody who really knows how to do a foreclosure. Mr. Basili fit that picture. But Mr. Basili had never been officially designated as the substitute trustee. And that is the reason that the underwriters said we should take this person out of here, because that foreclosure never happened. And he never had the authority to have conducted the foreclosure. So that's why it was eliminated. There was nothing nefarious about deleting that reference to somebody who didn't belong in there in the first place and who'd been initially placed in the deed at the request of underwriters, the title insurance underwriter, and removed at the title insurance underwriter's behest. I also want to say the recorder of deeds does have the authority to audit transactions and does so, and actually did so in this case with reference to a different subject, which was whether the proper tax had been computed with regard to the deed of trust. That's a separate issue. I'm not going to get into it in this case, but that was an audit that was conducted, and that's in contrast to the absence of an audit relating to the consideration here. So it could have been challenged and it wasn't. Nobody has ever claimed that the amount of tax paid on this no one with authority, I should say, I'm not talking about counsel, but no one with authority has ever claimed that the taxes paid were improper. Finally, I want to deal with one case nobody has referenced, and that's the Hodes case. This is one that I call to the court's attention because it came down after we learned of it after our brief had been filed. And Hodes was a similar situation, although it's a reciprocal discipline case. So
that makes all the difference, doesn't it?
Well, yes and no.
Discipline?
I don't think so, because I think the court has to conclude that the discipline that was imposed in Florida is within the range of what would have been accepted had the same action taken place in DC. And what Hodes did was very similar to what Mr. Soto did. He changed a document after it had been executed and notarized and submitted it, and did so without any fraudulent or improper intent, only because he realized he'd made a mistake. And he didn't go back to the original signer of the deed to get it fixed. He just went ahead and did this. And the court in Florida sanctioned him with a 60-day suspension, and this court approved that same sanction. So I think it is relevant. Finally, I do think there's an ultimate fact issue about Mr. Soto's intent that would warrant this court in going back to the de novo consideration of whether he intended to do something improper in endorsing the letter that his counsel wrote. And I do want to call your attention to the fact that the disciplinary proceedings began with a letter from disciplinary counsel on March 25th. This letter from respondents counsel was May 15th. So in that less than 2-month period, respondents counsel had to try to get her arms around this very complicated transaction, which took 7 days to unearth in the courtroom with 15 witnesses. You can understand, I think, why the letter didn't deal with each of the elements in this long chain of events, and it wouldn't have mattered had it done so.
Thank you, counsel.
Thank you, Your Honors.
Thank you to both counsel for the briefs and arguments. The case is submitted.
All right.